But I want to get to Zubik, because this is another case. I mean, folks, we've had now two cases, very specifically, and in fact, I would argue maybe even three, but two directly, where the death of Antonin Scalia has prevented the right wing from cutting into our rights as Americans, frankly. The first, of course, was Friedrich, which would have seriously undermined the ability for public sector unions to exist. I mean, by all accounts, it would have largely destroyed public sector unions, which, of course, is the last bastion of unionhood in this country. And because of Antonin Scalia's death, I mean, this is the but for, as we used to say in law school, but for Antonin Scalia's death, the Friedrich case, which involved the question as to whether or not unions would have to be or could be the exclusive bargainer on behalf of public sector workers to a municipality or to a state or to a county or to a federal or to the federal government, and would have to bargain on behalf of all the workers who are working in that agency or force or whatever it was. And yet those workers would not have to pay any agency fees, essentially, any dues at all to the union. So basically they would get free representation. And this stuff costs money, of course. By all accounts, this was going to be the, probably not the first, but probably the largest assault on public sector unions we've had in this country since probably Taft-Hartley. And because Antonin Scalia is dead and died when he died, didn't happen. 4-4. Case basically goes away. Well, in Zubik, a similar dynamic. It's probably not going to go away. It's probably going to come back. But the case in Zubik v. Burwell is an Affordable Care Act case. It is sort of the child, the nephew, the niece of Hobby Lobby. There is, as you know, in the Affordable Care Act, a mandate for insurance plans to cover contraceptive care for women. There's a bunch of other mandates, too. You need to be able to get a colon cancer screening. I can't even say the name of those things. Colonoscopy, yeah. So my last one was too uncomfortable to... I think I blocked out the name.
I just got uncomfortable.
Oh, believe me.
Yeah.
Wait till it really along. Begins, buddy.
Okay.
Anyways.
Kombucha
but a colonoscopy, I remember when, that I was recommended by my doctor to start having them at age 40 because there was no history of cancer, but there was a history of polyps in my family. Well, we don't need to go any deeper, as it were. But when I went to go see, and I didn't understand this until like literally 10 years later, 5 years later. And I think actually on Break Room Live, we videotaped it, my colonoscopy. We don't need to talk about that.
But apparently you want to.
When I went to the insurance company, when I went to the colonoscopy doctor, and I went to the nurse at the front desk or the receptionist or whatever, the administrator, she said, why are you here? And I said, well, obviously I had made the appointment. Why are you here? Well, my doctor said I got to come and get a colonoscopy. And she said, is there bleeding? And I said, what do you mean? And she goes, you want to say there's bleeding because insurance will cover it that way. I'm like, okay. And It was some exchange like that.
I'm bleeding all over. I can barely even feel and hear myself, and I don't even know about Social Security reports.
Well, but here's
no
the
more.
point. Here's the point, is that these preventative procedures, which were prescribed to me by my doctor, were apparently not covered this doctor, ultimately, I didn't go back to for the second round because that was the whole thing I had with whether or not they would give me the proper anesthesia, whatever it was. But the bottom line is that's another thing that insurance mandates. That's a long way of saying, it's not just, before the men's rights activists get the hackles up, it's not just a free giveaway to women, slutty women, as Rush Limbaugh famously said about Sandra Fluck. And so this case, there was exceptions that were put in for-profit entities where, and this was carved out in Hobby Lobby, where because it would offend the sensibilities of certain religious organizations or religious people to provide contraceptive care for their workers, there was a system put in place where they would just inform the insurance company, we don't want to do it. And the insurance company would then just turn to the government and they would offer it anyways. And in the case of Zubik, which ostensibly is this little organization of nuns, but it's really more to do with a Catholic nursing home company where there's multiple nursing homes, where they hire employees of all different faiths. The idea that they would fill out a 2-page form saying that they don't want to provide contraceptive care because it offends their religious sensibilities was too much. And the argument is that even telling the insurance company on a 2-page form was too much of a burden on our expression of religion. This is what it was about. And we can't do it. And yeah, that's right. The Catholics are they got a lot of chutzpah. And so this basically comes down to the question of, can there be a compromise where there's something where they can be at arm's length enough from this? And basically, because the court knew that it could not come to a resolution because it's 4-4, because Anton Scalia is dead. I'm not going to do the dance right now. Okay. We'll do it at the end of it. Because Anton Scalia is dead, the court issued an opinion and basically did not rule on any question of law, just rather whether or not it was possible for a compromise to be made. And they basically sent it down to the lower courts, 7 of 8, I believe, which have ruled already, federal appellate courts, that this is not too much of a burden. But it basically sent it down to them and said, come up with some solution. And this is the key part of the opinion. Both petitioners, that would be Zubik, and the government now confirm that such an option is feasible. That feasible they were talking about was whether contraceptive coverage could be provided to petitioners' employees through petitioners' insurance companies without any such notice from the petitioners. In other words, can the insurance companies just automatically give it to the plaintiff's employees without the petitioners knowing it, essentially? And the court said the petitioners and government now confirm such an option is feasible. Petitioners have clarified that their religious exercise is not infringed where they, quote, need to do nothing more than contract for a plan that does not include coverage for some or all forms of contraception. In other words, they thought they were being very cute, the Zubik folks, by saying the only instance where our religious freedom is not being infringed upon is when we can sign up for an insurance plan that does not include coverage for some or all forms of contraception. Now, theoretically, what they could have said is, our religious liberty cannot be infringed only in the instance when people who are working for us do not have access to contraceptive care through an insurance company that we do business with. Now, that would have seemed somewhat unreasonable, but that's where they wanted to go. They thought they were getting there with this. But a 4-4 split of the Supreme Court now says that the government has confirmed that the challenge procedure for employees, this is a quote, for employers with insured plans could be modified to operate in the manner posited in the court's order while still ensuring that the affected women receive contraceptive coverage seamlessly together with the rest of their health coverage. In other words, the government could just say to insurance companies, theoretically, if you are providing health insurance and anybody who you've contracted with, and you should just automatically provide it to employers through some backdoor mechanism. Set it up. Period. Automatically. So that places like these nursing homes can pretend they have no awareness this is happening. And now, were this a 5-4 court, they could have very well ruled on whether or not Zubik's religious liberty was infringed by just simply having employees that they knew were getting contraceptive coverage through the fact that they were their employees. So in other words, I hire you, you get insurance from the company that I have contracted, even though they don't offer, even though the plan that we're buying does not offer contraceptive care, the fact that you're our employee means that that insurance company has now had their bureaucracy triggered and will then provide you a supplemental contraceptive care. And if you don't think that Antonin Scalia would have ruled in that favor, you're delusional. I don't know that anybody would. I mean, but this is just another example. And look, understand, this is the way that law is built, right? I mean, if that becomes an infringement, if the just simple fact that because I've contracted with party B, and party B gives it to my employer because they're my employer, if that is an infringement of my religious liberty, you understand the implications of that. I mean, what's stunning to me is that, I mean, these nuns who are against capital punishment, I mean, they pay taxes to a government that is involved. Why? I mean, I guess they don't pay taxes. I guess that's the point. But their employees do. I just don't understand. But that's what their thing is. Hello, you. I'm Sam Seder. Looking for smart progressive talk that is occasionally amusing? Well, subscribe to our YouTube feed. Subscribe to our podcast. Like us on Facebook. And just generally enjoy us.